Okay, so today's another hot one, so you will get the background noise of the aircon and the evaporative cooler. So, I'm a little bit annoyed right now with this moronic defence team. I noticed that they have filed more motions for the DP case, but the thing that's really bugging me is now they've filed this motion to have all evidence found on his Google Drive thrown out. What would that mean for the CSAM case? That would basically shoot the case completely out of the water and basically allow him to get off from 60-something charges. Is it going to happen? No way. Like I said, I did a video, if you haven't seen it, where I talked about Judge Keith Carson. He is well versed in statute, he's well versed in precedent, and he is a very, very experienced judge. He's not going to take any of this crap that's coming out from the defence. But I wanted to go through it anyway. Now, I haven't looked yet at this motion in terms of the Google Drive, but I'm going to presume that their argument here is that the warrant for the Google Drive was based on them finding images on his phones, and they're basically saying that since his phone was illegally seized, that evidence is null and void, and therefore the search warrant for the Google Drive would also be null and void because they wouldn't have known to search his Google Drive had they not searched his phone. Well, I've already spoken about the whole notion of them searching his phone being surely legal, given the circumstances, given the discussion that we've heard, and I played clips from the audio when his phone was taken, and I'll link all those videos below. But I think that they were well and truly within the law when they seized the phone, and as you guys know, I'm a bit of a fan of Detective Myra Tagler because I think she's a pretty damn good detective. And it really bugs me that they are going after her. Perhaps this is some female thing. I don't know. Maybe this Vickers woman doesn't like other women. Or maybe it's just a convenient argument having been raised previously with the Corey Richards trial. So I've already done a number of videos on this, but I wanted to go through, now the documents are available for the motions regarding Stefan's phone and regarding his Google Drive. I wanted to go through them. There's probably bits that I will skip through because they are once again quite lengthy motions. It seems like this defence team is determined to waste money and waste time on frivolous motions. So let's jump in, and we need to have a bit of an understanding of what they're saying with the phone motions first before we look at the Google Drive, because clearly they are all interconnected. Like I said, I don't think this judge is going to let this fly, but let's have a look at it anyway. So we have a motion to suppress evidence obtained from unlawful seizure of cell phone. I'm pretty certain that the prosecution will be able to prove that it was lawful, and I think I've shown that now in the videos that I've done. Comes now the defendant, Stephen Stearns, by and through his counsel, yada yada yada, hereby moves this honourable court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful seizure of his cell phone. As grounds for this motion, the defendant states. So even in this motion, you can predict that the Google Drive is connected because they're saying directly and indirectly. Now, there's probably going to be a lot of legal dribble through this, where they start citing 50 million cases that are probably not remotely related to this particular instance. So those bits I will skip over. I'm more interested in the nuts and bolts of what is being said here. This case presents a flagrant violation of Mr. Stearns' constitutional rights under the Fourth Amendment. Detective Tagler with the Orange County Sheriff's Office unilaterally seized Mr. Stearns' cell phone without consent, without a warrant, and without exigent circumstances. The phone was then retained for over 9.5 hours before law enforcement coerced a purported consent for its forensic examination. Because this seizure was unlawful and all evidence obtained bears the taint of this initial illegality, the court should suppress the cell phone evidence and all derivative fruits. Now, I'm going to stop it right there, because we simply need to go and look at the interview that was done with Stephen Stearns on the 27th with Detective Tagler. And in that interview, you can hear the chain of events. You hear Detective Tagler asking if she can look at his phone. You hear her then clarifying quite clearly with him that it is okay for her to look at his phone. And they are questioning the fact that his phone has been factory reset. There's no messages prior to the day before. Now, in that same interview, Detective Tagler asks permission for them to further search his phone. That permission is clearly given, and we have that on a recording. And then she asks him, is it okay for them to access it, or do they need to get a warrant? And he makes it quite clear that they are okay to access it, and he gives them his PIN number. So, he gave consent for her to have his phone, for starters. Exigent circumstances. There was a 13-year-old child missing, and at that point in time, they still believed that there was a possibility that Maddie may be alive. They had Stearns lying, contradicting himself. They had Jen's stories contradicting Stefan's stories, and they had evidence from CCTV cameras which showed Stearns driving around with Maddie in his car, deceased. Does that not count as exigent circumstances? They're saying the phone was then retained for over 9.5 hours before law enforcement coerced a purported consent for its forensic examination. Well, can I just say straight up, bullshit? Because that was not a 9.5 hour interview. And you can go and listen to that interview. If you go to my case list playlist, then you go to the interview or Stephen Stern interviews from 27th, 28th, and you look for the 27th interview, I believe. That is the interview that was done with Myra Tagler, and you can see that I think it was only about an hour and a half long, so not 9.5 hours. The consent was given freely. You can hear that in the interview. We also have interviews with Jen and Chris, where they talk about Stefan discussing with them the issue of handing over the phone, and him asking whether it was the right thing to do, and them saying, if you've got nothing to hide, do it. So there is more than enough evidence to show that he understood what was going on and that he gave his consent freely. Okay, so moving on. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search of Mr. Stern's phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of this unconstitutional seizure. So, yeah, I was right. They're basically claiming that the Google warrant, because it was based on what they found on his phone, is unlawful. They would first have to prove that seizure of the phone was unlawful, and I don't think it was. Evidence to be suppressed. Any and all tangible and or intangible evidence obtained contemporaneous to and following the illegal seizure of Stefan Michael Stearns' cell phone, specifically including but not limited to all data obtained from the subsequent download of the phone, all evidence obtained through execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. In other words, it would mean that the whole case would be thrown out. Now, I think any judge who were to actually pass this motion would find themselves out of a job. We're talking over 60 charges here relating to CSAM. So no judge is going to pass a motion like this when it can be clearly proved by the prosecution that it was done legally. Stefan Michael Stearns has standing under the Fourth Amendment as he was the owner and possessor of the cell phone that was illegally seized on February 27th, 28th. So she doesn't even know the date that it occurred. That cell phones, Riley v. California establishes that cell phones are entitled to heightened Fourth Amendment protection due to vast amount of private information they contain. Yeah, I'm sure that when the Fourth Amendment was written, it was written to protect people's cell phones. Honestly. The moving party's initial burden has been met through documented evidence of a warrantless seizure in law enforcement reports. Once established that a seizure occurred without a warrant, the burden shifts to the state to prove an exception applies. Okay, so this is where I think we do need a Maddie's law, something that's going to protect evidence in future cases. A law which basically allows for detectives to seize and download the contents of mobile phones of immediate family members of children who are missing. I think if someone is innocent, they'd be more than happy to allow that to happen. Obviously, if nothing is found on the phone is going to be returned, and that's going to be a time-efficient way of beginning to eliminate immediate family members, which allows detectives to focus further out if those family members are innocent. Let's have a look at what they're saying in terms of statement of fact. On February 26, 2024, at approximately 2000 hours, 8 p.m, Jennifer Soto reported her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. Well, that's wrong for starters, and we know that. We know that officers finally turned up at the offices where Yolanda worked sometime after 7, but the report was made before 5 o'clock. On February 27th, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Stearns. Notice they're not going to mention anything here about the photos, like the CCTV images that they had, or interviews with people such as the guard on the gate. This is all going to be carefully left out because that proves probable cause. Detective Myra Tagler of the Orange County Sheriff's Office was assigned as lead investigator. On February 27th, approximately 1600 hours, 4 p.m, Detective Tagler, accompanied by Detective Acosta, contacted Mr. Stearns at his residence. The interactions with Mr. Stearns were audio recorded and captured the exchanges between law enforcement and Mr. Stearns. Mr. Stearns' residence is located at Santa Maria Drive, Kissimmee, Florida, blah blah blah. Detective Tagler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check his Google login status by asking, "Is it okay if I go into your settings real quick? I just want to see if you are logged into your Google." Mr. Stearns responded yeah to this specific and limited request. After exceeding the scope of this limited consent, Detective Tagler unilaterally announced, "I'm going to hold on to your phone and I'll give it back to you when we're done." And I do believe that he gave consent to that. Now let's talk about her wanting to check his settings to see if he's logged into Google. So basically, she checked out his Google account. She would have seen the images, hence the reason her saying, "I'm going to hold on to your phone." So I believe right there gives probable cause. They're looking for a missing child. The detective looks at his phone, sees these images. Of course, that is surely enough cause for them to keep the phone. Mr. Stearns expressed explicit concern about maintaining contact with his father through that phone. Detective Tagler dismissed Mr. Stearns' concerns by stating they could call Ms. Soto's phone instead. Now, I have covered this in the video that I did when I was talking about the Corey Richards case, and I do believe that in each instance, because Myra Tagler is pretty damn efficient, she still got his consent. So I believe that after saying that Chris could contact Jen's phone, that they still gained Stearns' permission. Either way, if you go and listen to the video that I did when I discussed this with the Corey Richards case, you can hear quite clearly that they gained his consent the entire way through. He knew what they were doing. He never once said no. He continued to consent. Mr. Stearns was given no choice regarding the seizure of his phone. Yes, he was. No consent was sought for the seizure of the phone. They've just repeated themselves. Duh. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. I believe they didn't obtain a search warrant for the phone, but they did obtain a search warrant for the Google Drive, and they have his consent clearly given on audio. Detectives did not present Mr. Stearns with a written consent form for the seizure. Detectives did not advise Mr. Stearns of his right to refuse consent. The detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. The detectives did not document any exigent circumstances justifying the warrantless seizure. I believe they did because they were looking for a missing child at the time. I think that trumps all this. On February 28th, at approximately 1:30, detectives again contacted Mr. Stearns. Actually, it was shortly after midnight, I believe. This second contact occurred approximately 9.5 hours after the initial seizure of his phone. During this midnight contact, detectives referenced their earlier unauthorised seizure, stating, "I told you I was going to hold on to it and that we would like to download your phone right." The detectives presented Mr. Stearns with an ultimatum. "Is this something I have your consent to do, or do I need to get a search warrant for your phone?" So it was in two separate interviews. I stand corrected. I apologise for that. Although I will be checking on this. It didn't sound like an ultimatum to me. It sounded like a, "Is it okay for us to do this, or would you prefer we get a search warrant?" You could see it as an ultimatum, or you could see it as presenting choices. The tone of voice to me sounded like presenting choices. At the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures. Actually, him and Jen had been sitting in Jen's car for 4 hours. So no, he was not detained outside. Mr. Stearns was wearing only flip-flops, khaki pants and a thin hoodie. Oh, poor little boy. What a pile of crap. He was sitting inside Jen's car. If he was not dressed adequately for the weather, that's his problem, because that latter interview didn't start till midnight. So it's not like they had grabbed him at 12 o'clock in the middle of the day and said, "Well, sit here and wait." Even if you account for the 4 hours sitting in the car, that's still from like 8 o'clock at night that they were sitting in Jen's car. So if he wasn't adequately dressed, that's on him. Like I said, he wasn't outside anyway. Stearns had not eaten all day prior to the incident. Oh, God, this guy just makes excuses for everything. I'm really looking forward to seeing the prosecution just nail this guy's ass. Mr. Stearns was not allowed to return to Miss Soto's vehicle, which was heated despite the cold weather conditions. BS. And there is audio where detectives specifically discuss with Jen the fact that her and Stefan were sitting in her vehicle for 4 hours that evening. So that can be proven as an outright lie. Earlier that night, Mr. Stearns had taken Ativan, a prescription medication to manage his panic attacks. Mr. Stearns clarified to the authorities that he had taken tranquilizers to help him sleep, as he'd been struggling with insomnia. BS. The reason Stefan was tired was because he'd been driving about at 3 a.m. the night before. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. Ativan is also known to cause drowsiness, sedation, and impaired alertness. Mr. Stearns described the effects of Ativan to law enforcement, stating, "This is why I missed your calls. I'm sorry. I took Ativan and conked out for a few hours." Bullshit. I'm probably going to be demonetised now for saying that. But honest to goodness, I'd like to see evidence, first of all, that he was so drugged out, conked out. The only medications he was probably on were illegal drugs. He sounded quite coherent in this interview, aside from his little pissy, Stearnsy voice, which can be proven as his standard voice for these interviews because he used it in every single interview. So there is no sign in this interview of him sounding drowsy, of him sounding out of it, anything like that. He just sounds like baby boy Stephen Stearns speaking in his usual manner. So I'd like to see them provide the actual evidence for this. Either way, it sounds like he was pretty clear in terms of them being allowed to seize his phone. He gave them permission. He also discussed it with Jen and Chris. This is all recorded. He's got no leg to stand on. At approximately 0240 hours, so 2:40 a.m, February 28th, Mr. Stearns' phone was taken to the Orange County Sheriff's Office Digital Forensics Unit. Okay, whatever. The warrantless seizure of Mr. Stearns' cell phone was unconstitutional. Fourth Amendment protects against unreasonable seizures of property. I believe it was more than reasonable, and I believe that prosecution will prove that, even when no search has taken place. A seizure of property occurs when there is some meaningful interference with an individual's possessory interests in that property. The instant matter presents precisely such a meaningful interference, as Detective Tagler unilaterally seized and retained Mr. Stearns' cell phone for over 9 hours without consent or probable cause. Right there. Probable cause. They were desperately scrambling to find Maddie at that point. That is your probable cause. This Vickers woman, or whoever wrote this on her behalf, can go and jam this entire document up their, you know what. So like I said, I've skipped over a bit of precedent, or supposed precedent there. While law enforcement may temporarily seize property to prevent the destruction of evidence while seeking a warrant, such seizures must be properly limited in scope. The United States Supreme Court has emphasised that courts must consider the length of the detention in determining whether a seizure is reasonable. The Supreme Court held in place that even when supported by reasonable suspicion, a 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed unreasonable in place. Sorry! I'm just going to read that again. Unsupported by any reasonable suspicion. What? This is a fiction. This is a work of fiction. I've just said the grounds that they had. They had a missing child. He was the last person known to have been with that child. They have CCTV footage of him with her in the car, appearing to be deceased. They have a witness who said that he went through the gate with the clicker. They pressed the clicker for him and saw Maddie basically essentially lifeless, although they didn't realise that's what they were seeing. They said they saw this woman not moving, lying in the seat. They didn't see her face. So many things here that create reasonable suspicion. Not only that, I'm pretty certain that when Myra went to check if he was logged into his Google account, that having accessed his Google account, she would have seen the images. In which case, a 90-minute detention is not even remotely adequate. Of course, they had due cause. The judge is going to throw this out. I'm just going to say that. Now, because they can't find decent precedent relating to anything similar to this case, now they're talking about, in the next paragraph, retention of identification during a warrants check, and saying that not all encounters with law enforcement and citizens constitute seizures. So now they're trying to say that if someone's pulled over and police take their licence and hold on to it while they do a check over the radio, like, I'm sorry, that's standard practice in Australia too. Sounds like that's what they are trying to say. Detective Tagler effected a full seizure by unilaterally, they love that word, don't they, announcing she was taking possession of the phone without seeking consent, retaining it for over 9 hours and completely depriving Mr. Stearns of his ability to communicate with family members. They did not completely deprive Mr. Stearns of his ability to communicate with family members. He had Jen's phone, and in fact, what occurred after his phone was seized, him and Jen sat in Jen's car and made a phone call to Chris. And you can hear in the interviews with Chris where he specifically says that during that phone call, they basically were on speakerphone and both of them were speaking. So he was not deprived of his ability to communicate with family members. So that is an out-and-out lie. The extended duration and complete deprivation of Mr. Stearns' possessory interest in his phone demonstrates why this case falls squarely within places holding that even brief investigative detentions of property must be properly limited in scope and duration. This is just such a load of crap. Detective Tagler made no attempt to obtain a warrant despite the availability of an emergency duty judge system and ample time to do so during the initial seizure. Okay, probably true. Instead, Detective Tagler retained the phone for over 9 hours without providing any indication of when or how it would be returned. Well, there's nothing in the law that says that you have to indicate when the phone will be returned. I'm pretty certain of that. Far exceeding any reasonable scope or duration under Fourth Amendment jurisprudence. What a crock. The length of the detention alone precludes any argument that this was properly limited investigative detention under Place and its progeny. Okay, I'm not going to play back through all these interviews, but just to give you a bit of a reference, like I said, if you want to go and have a look at the other videos I've done in relation to phone evidence, I'll put the link below. But the claim here is that they had his phone for 9.5 hours. They're also saying that he did not give permission. So what I've done here is I've gone back to the interviews and I'm using the transcript to give me an idea of times. Now, I probably should have shown you also that in this particular video there are 3 interviews, and this interview that was done at 7:16 p.m. is the second interview that was 20 minutes into the video. So if we look at the timestamp here where it says 40 minutes and 55 seconds, that's actually only 20 minutes into this interview. Hopefully I've not lost you there. So the interview started at 7:16 and the timestamp would have been roughly 20 minutes something. So the time that Myra asked him for his phone was 7:36 p.m. Keep this in mind. Okay. Now, you can see I've highlighted the transcript also. So if you look over to the side, her first question is, do you mind if I look at your maps real quick? And he says, yeah. He gave permission. And then she goes on with the questioning here. Next, a few minutes later, she asks, do you mind if I just take a picture of your history? And he replies with, yeah, that's fine. Again, given permission. When someone says, do you mind? Then the implication there in the question is that you can object. She's not just saying, I'm going to do this. She's saying, do you mind if I do this? If you ask someone if they mind something, it is there in the question. Is it okay? If not, you can say no. You just have to look at the speech. Okay, then a few minutes later, she asks, is it okay if I go into your settings real quick? I just want to see if you're logged onto your Google. He says, I'm not logged onto my Google, but she persists with, with that actually, is it okay if I check? And he says, yeah. Again, the sort of questioning there implies the option of saying no. Is it okay with you? You can say, no, it's not okay with you. I think it is quite clear in the way Myra is questioning him, and she clarifies when he doesn't give an adequate answer. So she makes sure that he understands what is being requested here. Now, just prior to the end of the interview is when she says, I'm going to hold on to your phone, okay. I'll give it back to you when we're done. So she does indicate that she's holding on to it and that it will be returned when they've actually done what they need to do. So it may not be an exact specific time frame, but it's pretty clear that they're not keeping it forever. And he says, okay. Moving on. Now, she even explains to him that she's waiting to hear from her supervisor with regards to the phone. And he says, it's just my dad's using it to get hold of me. And she says, they can call Jen. And he says, okay. Once again, he's acknowledged that yes, his father can call Jen, and that, well, is sort of what happened, because then after this, him and Jen rang Chris together. Okay, moving on. Okay, here's one for the mathematicians amongst you. In fact, you don't need to be much of a mathematician to figure this out. The second interview occurred at 12:16 a.m. Now, by my calculations, given that the previous interview began at 7:16 and the phone was taken 20 minutes later, that means his phone was taken at 7:36 p.m. This subsequent interview occurred at 12:16 a.m. And you can see the timestamp. It began at 1 hour and 3 minutes, nearly 1 hour and 4 minutes. Now, when did this next comment occur about the phone? So the conversation about the phone immediately starts at the beginning of this interview, 1:04:12, so about 12 seconds into the interview. So, did they have the phone for 9.5 hours at this point in time? No. You do the math. 7:36 to 12:16. That's not even 5 hours. By my calculations, that's 4 hours and 40 minutes. They've added an entire 5 hours onto the time frame here, claiming that it was 9.5 hours, which is complete and utter BS. As for saying that they didn't provide any indication of when or how it would be returned, as you heard, Myra specifically stated that it would be returned after they'd finished with it. She wasn't able to give an immediate time frame because she was waiting for instructions from her immediate supervisor. Okay, let's keep scanning through this document and see if there's anything else important here. The initial seizure exceeded the scope of any purported consent. While consent provides an exception to the Fourth Amendment's warrant requirement, yes, such consent is strictly circumcised by its express scope and circumstances. Specifically, what would the typical reasonable person have understood by the exchange between the officer and the suspect? Well, my understanding was that they wanted to have a look at his phone. This objective standard protects against law enforcement's unilateral expansion of narrowly granted permissions into broad investigative authority. That's not what occurred. Like I said, she asked if she could see if he was logged onto his Google account. The moment she went to his Google account, those images would have appeared. Florida courts have consistently enforced strict limitations on the scope of consent, recognising that permission granted for one limited purpose cannot justify broader government intrusion. Yeah, I really don't think they've got a leg to stand on here. These decisions reflect the bedrock principle that law enforcement may not exceed the reasonable scope of specifically granted consent. I really don't believe that they did. In the instant case, Mr. Stearns provided extremely limited consent for Detective Tagler to go into your settings real quick solely to see if you're logged into Google. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5 hour retention of the device, which it wasn't. 4.5 hours. Huge time difference there. This whole document is bullshit. Detective Tagler's unilateral announcement that she was going to hold on to your phone and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Stearns' limited consent. This expansion of authority mirrors the impermissible scope extensions rejected in both Appelt and Wells. Just as consent to look in a trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. Yes, but when you go to check that setting, and to do so, you have to open the Google app, at which point you see images. What else was she supposed to do? Now, hopefully I'm not repeating myself here. I did record a section earlier which actually didn't record. Love it when that happens. And I've had a lunch break, so now I'm back into it, and hopefully I'm not being repetitive. So, let's talk about this whole time frame and looking at reasonable things, yada yada. First of all, not 9.5 hours, but just over 4.5 hours, first of all. Big difference. As for just checking Google settings, Let's talk about what that entails. That means to see if someone's logged into Google, what do? You actually have to click on their Google app. Whatever app, whether it's Google Emails, Google Drive, whatever. You're going to have to click on one of those to see if they're logged in. So clearly Myra has clicked on his Google app, which clearly came up as his Google Drive, and surprise, surprise, there's some images in there that she probably didn't want to have to see, but she saw. Because if he was logged in, that would have come up instantaneously. So she was still basically checking that he was logged into Google. It's just unfortunate for him that those images came up. Is that beyond the scope of what she said she was going to do? No, it's not. Does she have to say to him, I'm going to keep your phone because I've just discovered a bunch of CSAM images on your phone? No, she doesn't. Because the priority then was to find Maddie. Which meant she needed to talk to the other detectives, she needed to talk to her supervisor, and they as a team needed to decide the best way forward. And if that meant them having that up their sleeve and Stefan being unaware that they knew about these images, then that's what they're going to do. They weren't going to do anything that was going to jeopardise their chances of finding Maddie. Because at that point in time, they still weren't sure if Maddie was alive or Maddie was deceased. So the way the investigation was being handled was crucial. Did she do anything wrong? I don't believe so. I think this whole document is just a pile of crap. I'm just going to read the subtitles now in terms of what they're trying to say, as opposed to just waffling on through this ridiculous document. So they're claiming no exigent circumstances justified the extended seizure. You have a missing 13-year-old child, no idea of her location, no idea if she is alive or deceased, and you know that he is the last person with that child. He himself admits he was the last person with that child. You have images showing her in his car the morning that she vanished. And yet they're claiming no exigent circumstances. So for anyone who's not sure what I'm saying here, exigent circumstances means urgent circumstances that mean that basically going through all the protocol of getting a warrant is going to cause a delay that could be extremely detrimental. In this instance, they believed that a delay could have been detrimental to Maddie. They didn't know where she was. They didn't know if she was alive. A delay potentially could have cost her her life if she was still alive. So yes, there definitely were exigent circumstances, and I'm pretty certain that this is enough to throw this whole document out. So, totally irrelevant here. They say, well, first, there's no hot pursuit of a fleeing suspect that would justify a warrantless seizure. No imminent destruction of evidence. Well, hello. Actually, that could be argued because he had already factory reset his phone twice. And we know that his actions after having his phone seized was to go down to his parents' house at Northport, into the house, remove the hard drive from his computer. That hard drive was never reclaimed. Don't know what he did with it, but that was lost. So I think that alone, his subsequent actions, his prior actions and his subsequent actions show that there actually was imminent destruction of evidence. He had already attempted to destroy evidence. So I think we can argue that quite successfully. And this one is clearly outlined in other warrants, so can be demonstrated quite easily. They're claiming here, third, no emergency aid circumstances existed. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the agency aid doctrine. This argument fails. The emergency aid exception requires law enforcement to have an objectively reasonable basis to believe that an emergency exists, requiring immediate action to prevent imminent harm. Right, now let's talk about that. They have CCTV footage of Maddie in Stearns' vehicle, looking either deceased or drugged up to the eyeballs. She was either deceased or unconscious. They don't know where he took her. From the images, they could speculate that she was deceased. But until they found her, they could not be certain that she wasn't. They could not be certain that she wasn't somewhere unconscious in need of medical aid, urgent medical aid. There was no evidence, solid evidence there that she was deceased. The guard at the gate didn't see her face. All he said was that she wasn't moving. The CCTV footage shows that in each one of the images, she remained in the same position. You could argue that that shows she was already deceased, or you could argue that she was unconscious. What sort of lawsuit would they be facing if they did not do everything in their power to try and discover this child's whereabouts, and it came out later that the child had still been alive for some period of time? Now, we know that that's not the case, but at the time that they took his phone, they didn't know that. And it's been made quite clear in other warrants in terms of the entry to the storage unit down at Northport, which occurred the day after his phone was seized. They outlined that pretty damn clearly. They also, when they interviewed Chris Stearns the following day, said that this was an urgent thing because they were concerned that he may have left Maddie somewhere. So I think they can well and truly prove that there was an emergency in terms of locating Maddie if she was still alive. Well, this is also a rather piss-weak argument. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 8 o'clock on February 26th. Wrong. They can't even get the timeline straight. Yet Detective Tagler did not seize the phone until 4 p.m. Actually, no. She seized the phone at approximately 7:36 on February 27th, some 20 hours later. The significant delay undermines any argument that immediate warrantless seizure was imperative. let's talk about what was going on during that interview when the phone was seized. This was the interview when Stefan was outright lying, and it was becoming extremely apparent to detectives that he couldn't even get his story straight within a 5-minute time frame. He was contradicting himself and quite clearly lying throughout that entire interview. Before then, may not have been as apparent. Did they have CCTV footage at 8 o'clock the night before? No, they didn't. That came later also. This was a developing investigation, meaning that, of course, they're not going to have all the information that they need when the child is first reported missing to be able to justify taking the phone without a warrant. At the end of the day, he did give permission. So this again goes back to what I was saying before. I think we do need a Maddie's law, and that it should be standard protocol to download parents' phones or phones of family members connected to children as soon as the child is reported missing. If it's standard protocol, then it's something for everyone. There's none of this BS later on. Even assuming, arguendo, that emergency circumstances initially justified seizing the phone, this would not excuse the failure to obtain a warrant during the subsequent 9.5 hours of possession. 4.5 hours, not 9.5 hours. This document is inaccurate. The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life or render first aid, provided they do not enter with an accompanying intent either to arrest or search. Okay. Now this is a huge presumption. Detective Tagler's own statements reveal the investigatory purpose behind the seizure, as she explicitly told Mr. Stearns, I told you I was going to hold on to it and that we would like to download your phone, right? Demonstrating from the outset that her intent was to conduct a forensic search rather than address any emergency. The emergency was a missing child. I really hope the judge just kicks these lawyers up the arse big time. Once the phone was secured, any emergency justification for the warrantless seizure dissipated, and officers were required to obtain a warrant for continued possession and examination. Their failure to do so, despite the availability of an emergency duty judge, demonstrates that true emergency circumstances did not exist. Detective Tagler's own actions belie any claim of emergency. I don't believe they did. I've said my piece here. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorisation. Once again, I believe that it will come out in court that the decision to seize the phone occurred because of opening his Google files and seeing images. I think that well and truly justifies the decision to seize the phone. Okay, I've skipped a chunk here. Like I've mentioned with previous documents, you can go to my Patreon. You can join for free and you can download these documents for free if you want to read the full document yourself. But I think in this document we're already up to page like 11 or 12, and it's a little bit better written than some of the motions we've looked at, but there's still a lot of irrelevant crap here. So let's look at point 3. All evidence derived from the unlawful seizure must be suppressed. When consent is obtained after illegal police activity, such as an unauthorised seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. That is, of course, up for argument. They're basically arguing fruit of the poisonous tree, saying that any evidence that was found on the phone is therefore inadmissible. I think I've well and truly pointed out why it is perfectly acceptable and why this should be thrown out in court. So here's their argument. Here, there was no break in the chain of illegality between the unconstitutional seizure and subsequent searches of the phone. The extended deprivation of Mr. Stearns' phone. How do you deprive a phone? Oh, I guess, yeah, it's just crap grammar, sorry. The extended deprivation of Mr. Stearns' phone created coercive circumstances that led to the midnight consent for its forensic examination. Before they just said there was no consent. Now they're saying consent in speech marks. Any purported consent was inexplicably intertwined with and the direct product of the illegal seizure. The Google warrant and all derivative evidence were direct products of the initial unlawful seizure, as law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through the exploitation of this unlawful seizure, including the phone's contents, the Google warrant results, and any investigative leads developed therefrom, must be suppressed as fruit of the poisonous tree. I'll just give everyone a moment to silently scream, because this is just a ridiculous document. This won't hold water. I feel quite confident that this won't hold water. I feel quite confident that this judge knows his stuff. And he knows statute law, he knows precedent law, and I think also a decent prosecutor could easily argue that there was probable cause. There was good reason to seize the phone. So basically now they're calling for an evidentiary hearing to go over the matter, which I hope that will be televised, because that could be very interesting. It's pathetic. That's all I have to say about it. Okay, let's have a quick look at the second document regarding the phone, about the downloading it without a warrant, just to see what the gist of that is. And then we'll jump through to the Google warrant. I'm pretty certain this document's not going to produce anything new, really. Motion to suppress evidence obtained from unlawful searches of cell phone. Comes now the defendant, Stephen Michael Stearns, blah blah blah, and hereby moves the Honourable Court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful searches of his cell phone. As grounds for this motion, the defendant states, this case presents two distinct and egregious violations of Mr. Stearns' Fourth Amendment rights by law enforcement, each flowing from and building up the other. First, Detective Tagler systematically exceeded the carefully circumscribed scope of Mr. Stearns' limited consent to merely check if you're logged in onto your Google, instead conducting a comprehensive search of his private cell phone data, including location history, call logs and other protected information. Second, law enforcement, already in possession of Mr. Stearns' phone through their earlier overreach, orchestrated a coercive late-night confrontation to extract consent for a complete forensic download of his device. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful seizure of Mr. Stearns' phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of these unconstitutional searches. So they're making some rather subjective claims here. I think at the end of the day, the reason they were doing so many interviews was not to pressure Stearns into giving them his phone and allowing them to do a search. They were trying to find Maddie. I don't know how many times I have to say this. This does my head in. And I know this is just them. They've got to try it. They've got to at least have a go. But this won't fly. This really won't fly. Evidence to be suppressed. Basically, they want everything that's suppressed, meaning that this whole case would be thrown out because the whole case is built around all the images. So pretty much, let's see what they're saying here. So evidence to be suppressed, any and all tangible or intangible evidence obtained contemporaneous to and following the illegal searches of Stephen Michael Stearns' cell phone, February 27th, 28th, specifically, including but not limited to all data obtained during the initial unauthorised search that exceeded the scope of Mr. Stearns' limited consent, including but not limited to location data. Well, they didn't get that off his phone. That's not relevant to where he took Maddie or anything. Call logs, text messages, browsing history, photographs, videos, and any other digital content accessed beyond checking Google login status. I'm sorry, but the moment you check someone's Google login status and see all these images, bam, there's your probable cause. You can forget getting your phone back, buddy, because you are just about to go to jail. All evidence obtained through the Cellbrite forensic extraction of Mr. Stearns' phone, including but not limited to extracted photographs and videos, text messages, communication records, location data, GPS, blah blah blah, blah blah blah, and any other digital evidence obtained through the Cellbrite process. So they're going to also try and use this now for his other case. Although I suspect that what they're doing here is they're going to try and throw this into this case, see if anything sticks, and then try and apply it in his other case. None of it will stick. So they've once again used the same timeline. I'm not going to read through all that because I don't think it's overly relevant and this would just be repetitive. Okay, I'll skip through to page 24 because honestly it's just not worth the time of trying to read through all this bullcrap. So let's look at how they finish off. The totality of circumstances surrounding the Cellbrite download consent reveals a calculated strategy to circumvent constitutional requirements through a combination of unlawful seizure, coercive tactics and exploitation of Mr. Stearns' vulnerable state. The 9.5-hour warrantless seizure, bullshit, 4.5 hours, just. The orchestrated midnight confrontation while Mr. Stearns was impaired by Ativan and subjected to physical discomfort, bullshit. The ultimatum, about obtaining a warrant and the deliberate avoidance of available warrant procedures all demonstrate that any consent was the product of coercion rather than free choice, when, as here, law enforcement systematically creates circumstances designed to compel compliance after than facilitate genuine voluntary choice, suppression is required. I've gone through all that. It wasn't coercion. He was given a choice. That's not coercion. If that's considered coercion, then when your child is at school and your child is climbing on top of a chair and yelling at another child, and the teacher says to that child, you've got a choice. You can hop down off that chair, sit down and get on with your work, or I can send someone to get the principal to have you removed, and that will escalate the situation. Is that coercion? No. That is giving a choice. Stearns was given a choice. Do we have permission to download the contents of your phone, or do we need to get a warrant? There's a choice there. He could have said, go ahead, get a warrant. But he gave permission. Okay, conclusion. Law enforcement's conduct in this case represents a flagrant disregard for the Fourth Amendment and well-established legal principles governing searches and seizures. Detective Taggler's unauthorised expansion of the limited consent given by Mr. Stearns, the prolonged warrantless seizure of his phone, and the coercive tactics employed to extract consent for a forensic download collectively demonstrate an egregious violation of constitutional protections. Under the totality of circumstances, Mr. Stearns' purported consent was the product of coercion rather than a voluntary, knowing and intelligent waiver of his rights. Oh, far out. I'm not going to read this whole paragraph. This is just, they're repeating everything they've said over 2 documents. I'll just go down to the 4th last line. It is required, given the deliberate and repeated constitutional violations in this case, suppression is the only remedy that restores Mr. Stearns' constitutional rights and deters future misconduct by law enforcement which flagrantly disregarded established Fourth Amendment safeguards. Now, obviously, this motion is going to be basically a repetition of everything they've already said. So let's just skim through it. And like I said, I'll put all this into Patreon for you. Motion to suppress evidence obtained from Google search warrant. Comes now the defendant, Stephen Michael Stearns, and hereby moves this honourable court to suppress all evidence obtained directly and indirectly from the execution of a search warrant for his Google account, sustenance@gmail.com, dated February 28th, 24th, and all fruits thereof. As grounds for this motion, the defendant states, this motion seeks suppression of all evidence obtained through execution of a Google account search warrant dated February 28, 24, as it represents the culmination of a series of deliberate Fourth Amendment violations. The warrant application relied entirely on evidence obtained through prior unconstitutional searches of the defendant's phone, beginning with law enforcement exceeding the scope of limited consent, followed by an unauthorised seizure, and culminating in a coerced midnight download. Rather than establish probable cause through lawful means, detectives relied entirely on evidence obtained through these unconstitutional searches to secure the Google warrant. This warrant application, built solely on the fruits of constitutional violations and lacking any independent source of probable cause, exemplifies the very type of illegal evidence laundering that the exclusionary rule was designed to prevent. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search and seizure of Mr. Stearns' phone. So they're basically just going with the same arguments. And they basically want all the 1,700 files to be excluded from evidence. I am actually going to read through what they want suppressed, because basically, if they were to get this motion through, this would also impact on the other case. So first of all, you have the 1,700 files of alleged contraband media spanning 2019 to 2024, associated metadata, location data, file creation, modification dates for these files, because of course all this was probably also on the hard drive of his computer, which is now gone. So I think he believes that if he can get this thrown out, they've got nothing. Private messaging data and communication records, cloud storage, backup data, location history and associated information. 2. All subscriber records, internet protocol logs, location data, yada yada, IP address logs, and connection records, device identifiers and associated hardware information, account passwords, security information and recovery data and user profile, and account settings data. So I don't think they would use the USBs that Chris gave them anyway, because they can't guarantee them as evidence because they came from Chris Stearns. But essentially, this would mean that any digital evidence would be thrown out. Nothing. So even if they were to somehow recover this missing hard drive, that would now become also unusable. 3. All fruits of the unlawful Google warrant, including physical evidence seized during subsequent searches on the Google data, witness statements and investigative leads derived from the Google records, law enforcement reports, analysis and investigative materials that incorporate or rely upon the Google data, expert analysis reports or testimony based on examination of the Google records. So basically, when they went into the townhouse and they seized a whole heap of evidentiary items based on the images found on his phone, all that evidence would have to be thrown out. All the clothing, all the pieces of bedding that were found, any Maddie's clothes, basically pretty much anything that would tie him to Maddie, aside from what they had from the day that she went missing. All testimonial evidence and witness statements referencing or incorporating information obtained from the Google account records. In other words, law enforcement couldn't talk about anything to do with the CSAM stuff or the items that were seized. Items such as the cream that he had in the backpack, any other items that were found in that bedroom 4, they're saying they would all be no longer admissible. Now, I'm not going to continue to go through this document, because basically it seems to me like they've set it up, they've used the whole argument about the phone being illegally seized, and this is all a flow on from that. So there's nothing new that's being introduced, but let's just look at the conclusion. The evidence in this case was obtained through a calculated series of escalating Fourth Amendment violations, each building upon the last, to systematically erode Mr. Stearns' constitutional rights. What began with a deceptively narrow request to check Google login settings evolved into an unauthorised seizure of his phone, comprehensive searches of private data, and ultimately the wholesale invasion of his Google account, all without valid consent or proper judicial authorisation. The Google warrant represents the culmination of these violations, relying entirely on tainted evidence while failing to establish probable cause through any independent source. There's your probable cause right there. That little girl. She was missing. They didn't know if she was still alive. They were on limited time. They needed to find her. I've gone through all this. I've explained the reasoning why this is not illegal. I support Detective Tagler. I believe that she was doing her job and she did it quite satisfactorily. I do think there is cause for a new law, a Maddie's law, so that this kind of bullshit can't happen at the trial phase, because it would be an absolute travesty, and I don't believe it would happen. I have faith, now that I've looked at this judge, that he will throw this out. I also believe that the prosecution team is pretty damn good. So I have faith that these motions will be thrown out. But to prevent this kind of thing from happening in future, I think we need a Maddie's law that allows for immediate tracking devices on vehicles, an immediate download of digital devices of anyone within the inner circle of that child's world. That will allow for future cases like this not to have BS written by moronic defence teams who are basically trying to have this case thrown out. I know I've been perhaps a little less than professional during the reading of this, but honestly, I'm not impressed with this defence team. I think they are wasting a heck of a lot of money on all these motions, and I understand that they're doing their job, but there is a point when it becomes excessive. Should these motions be accepted, that would destroy this case. This case would be out the window. And the 60-something charges against Stearns would be gone. What would that mean for his other case? That would mean that a lot of the evidence for his DP case would no longer be admissible. It would also mean that it could take the DP off the table because he would have no additional charges against him. So I think the goal here is still to avoid the DP. They know that he's guilty, and they're trying to minimise the consequences. And to that I say, this guy spent 37 years of his life avoiding consequences. It's about bloody time that he faced full consequences for all his actions. So thanks for listening. I'll leave it at that. Like I said, you can find these documents for free on my Patreon. You just go over, follow the link in the description. You can sign up for free, and then you can get whatever documents you're after also for free. I can, if you wish, read through the whole document for the Google Drive warrant, but I think it's basically 3 documents all repeating the same thing. They've used the same format pretty much throughout. They've used the timeline throughout. They pretty much use the same argument throughout. So it seems unnecessary to read through all 3 documents. So I know it's been a long one. Thanks for listening if you're still here. If you're new to my channel, please subscribe. Help me to grow my channel. Also, please help me by hitting the like button and leave a comment below. Thank you, and I'll catch you in the next one.